When you're going through a legal strife and you want to regain your life, don't stress, don't fuss, just call on us, 8333-REGAIN.
Again, I want to thank you all for joining me today, and obviously I want to thank the Single Fathers Network for putting this all together and even inviting me to be here to speak. So like he said, my name is Nancy Uko. I am an Arizona attorney, and I'm also the proud owner of Regain Law Firm. If you're here today, it's most likely because you're a single father and you're looking for some kind of understanding or guidance when it comes to one of the 4 points. That being, understanding what rights fathers have in family law here in Arizona, strategies for co-parenting effectively, how to navigate through child support or custody agreements, and how to locate resources to help you represent yourself while keeping costs as low as possible. Lucky for you guys, this is exactly what my firm focuses on exclusively every single day. It's all I work with is family rights. So you're getting the information straight from the source. And I think this is very important because I don't know how many times I have people come to me and say, you know, my friend got this outcome or my friend got that outcome, and they're expecting the same thing. I have an example of that. I have a case right now where father's fighting for rights to his 3-year-old son. Because of the conflict when the child was being born, he went ahead and signed a stipulated order giving mother full custody. So now that the child is old enough to leave mother and come and visit with him, he's fighting to get those rights back, and the judge gave him supervised visitations. And he tells me, Nancy, you know, my friend, he has a son the same age and he's going through the same situation. Why did the judge give him equal time easily, but is making me jump through hoops to get my equal time? And I said, well, did your friend sign a stipulated order releasing full custody? You know, did your friend stay away from this child for 3 years to the point where this child doesn't even know that you're his father? You know, so every case, your case is like your fingerprint. Every case is different. The facts of every single case is going to differ in one way or another. So it's not necessarily enough to know your friend's outcome. More so important to know the reasoning and the rules to why they got that outcome. And that's what I'm going to try to help you guys with here today. So with that said, I want to make sure that we are all clear on this. Content of this presentation does not constitute any legal advice, does not create any attorney-client relationship. It also does not create any of the benefit or privileges that comes with working with an attorney, and this presentation is solely for informational purposes only. Anybody have any questions on that? Okay, moving along, a little bit about myself. So I'm originally from San Diego, California. So beaches and blue skies. I came to Arizona with a full scholarship to attend ASU, where I received my undergraduate degree in pre-law justice studies. I stayed in Arizona to attend law school and ended up becoming licensed as an attorney in January 2016. In September 2022, I opened my own firm, and I decided to focus specifically on family law cases. I did this because of my own experience dealing with a high conflict divorce and having to figure out how to navigate co-parenting with a narcissist thereafter. So over the past 2 years, I've built my team, and we've worked very hard to brand ourselves as the narcissist slayers by helping people find relief from unhealthy situations with toxic exes that are not only negatively affecting their mental, emotional, and physical well-being, but are also affecting the lives of their children. So what I quickly learned in my practice as a narcissist slayer is that, contrary to popular belief, all narcissists are not men. In fact, there are a lot of them that are women. I don't know if you guys are familiar with this situation here, the Erica and Safari situation, but this is exactly what at least 50% of my clients are dealing with right now. As you can see, she's the aggressor. She's hitting him. He's literally on the phone with the police. She's blocking his exit. We can't hear it, but I'm sure she's calling him every name in the book, and all in front of the children. But I bet you, at the end of all of this, who's going to be the one to go down to the courthouse and play victim? I know it's not going to be him. Luckily for him in this situation, he had video footage. Or else this would have ended up being a very ugly he say, she say custody battle.
Oh, wow.
Oh, she's crazy.
She almost like an Amber Heard situation. situation.
Exactly. And she's going to go right to that court, try to get an order of protection against him, say that he was being the aggressor in order to get the kids. But it's situations like these that's the reason that I'm here to speak with you guys today. Because I have this theory that women act like this because they think that no matter what, the court is going to give them preferential treatment when it comes to child-related issues. They have this outdated belief that no matter what they do, the judge is going to side with them and believe that the children are best in the care of the mother. And they believe this because not enough fathers just dispute or challenge that presumption. And a lot of them don't do that because they don't know that once they establish their paternity, the court will actually afford them just as much rights to the child as they do the mother. But I'm getting ahead of myself, so we'll talk about that in a bit. Right now, I want to try to open up with a few icebreaker questions, kind of get a feel for my crowd, see what information you guys know already. First question is true or false? Being listed on a child's birth certificate automatically establishes your legal right as the father of that child. How many, raise your hand, believe that's false? Very good. Can anybody tell me why?
I don't know the why, I just know I went through it.
Yeah. You are absolutely correct. That is false. Although the birth certificate signing that is a presumption that you are the father, it's not enough. It's like evidence to prove that you are the father, but that instrument within itself is not enough to give you legal rights. You would have to take that document and go down to the court and file a petition to establish.
DNA test.
If the mother does not stipulate to the fact that you're the father.
I might be jumping ahead of myself, but like, how is that established as a rule, but then saying the case where like you're married and she has a child outside of the marriage, why do they automatically assume, why do you assume that in that situation, but then if you're on the birth certificate, they don't get the rights?
Yeah. Why the law is the way the law is, I couldn't tell you. I can just tell you what it is. But yeah, a lot of the things are backwards, but they have to go down to those meetings, like you were saying, and speak up and get changes made. But my first step is letting you guys know what the laws are so that you can act accordingly on them. True or false? You can get arrested for kidnapping your own child.
True.
Does anybody know why?
Unless there's something written by court order, and basically the court order is law.
Exactly. So if you go outside of those court orders, then technically you are in violation and you could be committing kidnapping over your own child. Correct.
Unless you're the mother.
Yes, and we'll talk about that in a bit. True or false? The parent with the more demanding work schedule is less likely to get equal parenting time.
True. False.
Oh, we've got a split there. Show of hands. How many people think that's true? Okay, how many think it's false? Can you explain to me, sir, why you think that's true?
It's a stereotype. I believe it I'm probably wrong. I just, from what I've seen over the years, the trauma I have is that.
That's, yeah.
They're less, it's less time.
I've definitely seen it used as a tool or attempted to be used as a tool for the other party to get more parenting time. But you don't think judges have long work hours? You don't think they want to come home and see their kids? So they understand that, and that's not something that they use nowadays to limit parenting time. Just because you work, that should not be used against you.
Was it back in the day?
Yeah. Things have really shifted in Arizona to be more of a father's rights state. True or false? Only fathers are ordered to pay child support.
False.
Great. I have to pay child support, unfortunately. So I know. And it really breaks down to, so child support is ordered in lieu of parenting time. If you're not exercising as much parenting time, then you get to pay child support instead. However, there can be situations where there's a disparity in the income. And that's my particular situation. If you make more than the other person, then you could be ordered to kind of fill that gap. In the court's eyes, if you two were together, there would be a certain amount of money that you would be spending collectively on the child. In the court's eyes, the child is still entitled to that, regardless of the fact that you guys are not together. So that's where that comes from. So if one person is making more, then they have to fill that gap in order for the child to get everything that the child is entitled to. Mother should not be allowed to use child support to pay for her rent, electricity, hair, nail appointments, or other personal needs. True or false?
Should not be allowed. Or is
Should not.
That's like
It's a matter of opinion. Yes. How many people are saying that mothers should not?
they should.
I mean, I think that depends. It's a
Right.
open-ended question to me.
Mm-hmm.
I mean, are they paying child support? Are they using money to take care of the child, or are they only taking care of or are they doing that like getting their hair and nail done and not taking care of the children?
Sorry, I think you were first.
My thing, I have different answers for the different things up there, because hair and nails, I don't think so.
Okay. Okay.
But appointments and electricity and rent and things of that nature, because that's directly related to caring for the child.
Mm-hmm.
Well, what appointments?
No, it's the hair and nail.
Well, I mean, obviously, I'm saying, like,
I love the way you guys think.
Yeah, it feels like wants and needs are all jammed in the same.
Mm-hmm. Mm-hmm. So let's say you're getting ordered to pay child support. Your child support comes out of your check if you get paid bi-weekly, twice a month, right? Is mother's rent waiting for your child support payment? Is mother's electricity or food, is that waiting on your child support payment? So she's paying her money that she would have been spending on her hair and her nails. So when she gets your child support check, then she can most definitely reimburse herself and go and get her hair and her nails done. So that's not an argument that you could take to the court. A lot of people try and they waste time, and I don't want nobody wasting time. True or false? Is it possible for a father to be deemed the primary residential parent, have primary care and custody of the child? Yes, I just told you guys about that situation before we got on the camera about the father who just got full custody because the mother is escorting on the days that she has the child. So of course, obviously we were able to show those posts to the judge. We were able to interview the children. The children said they don't see mom. They're left for days at a time. And father was given full custody and sole legal decision-making authority.
Real quick, you made a really good point the last slide. I never thought about it like that. I just want to point that out. About the reimbursing, you made a really good point. I've always been like, no.
Yeah.
Like, don't give them no money.
I had to throw that one in there. Okay. So when I was thinking about what to talk to you guys about, I'm like, how much information am I going to dump on them? And what I decided to do is just start at the beginning. What is the most frequent question that I get from single fathers? And this would be it. What do I need to do to establish my rights as a father? Now, the answer to this question can differ depending on who's asking. If you are a father who's married to the mother of the children, then the answer to that question is nothing. You don't have to do anything. In fact, every child that is produced from that marriage is automatically presumed by the court to be the child of that husband. So they don't have, they're automatic, the children are born with father and mother having equal rights. Yes.
So question on because I've had fathers ask this as well too though. So like when fathers are in the process of divorce and they're saying their child, their soon to be ex won't let them see their mother.
Yep.
But there's nothing set in court yet.
Yes.
Isn't there a
Yeah, we'll talk about that in just a second. Yeah, because that's a big one, especially for me. So you wouldn't necessarily need to file anything in court to have the equal parenting rights, but you would still want to go down to the court and have your parenting schedule established for the reasons that you were just touching on. Because once that parenting schedule is established, now you guys have legal recourse to you if in the event that you're being denied any type of parenting time from your child. So if mother doesn't have the child at the designated location, at the designated time, on the designated date, you could file charges for custodial interference against her. If mother takes the children out of state or out of the country during your parenting time without your knowledge or your consent, now with the court's backing, you have that power to charge her with kidnapping. Okay? But without that parenting schedule and with both parents having that equal parenting time, like Mr. Swan was saying, the lines of who has the child, when they have the child, for what duration they get the child starts to become blurred.
consequences of that first one? Fines? What exactly are the consequences?
Of what first one?
Like the first one that you mentioned,
Denied.
denied.
Times.
Yeah.
So with that, the police won't do anything. They say go to family court. Family court, the first instance, they're going to wave their finger. Second instance, they're probably still going to wave their finger. But after accumulating so many of those reports, you can strip her parenting time, her legal decision-making authority. There are certain consequences. But it takes time. It's not the $1 million, it's the 1 penny strategy that we were talking about, the penny a day. Yes. So you just got to kind of build that case against them.
Paper trail.
Exactly.
Screenshot.
Yep. So if you don't end up getting that parenting schedule, then if something was to happen, you technically don't have any recourse at that exact time and moment. And I'll use my case as an own personal example. I filed for divorce from my ex-husband, had him served. He went down to my child's daycare the exact same day, picked her up, and I didn't see her again for months. I go down to the daycare, they're like, well, we gave her to her dad. And I call the police, I said, I'm frantic at this point, I'm my only child, I'm young, I don't know what's going on. Calling the police thinking they're gonna help me. I don't know where my child is, I don't know where she is. Fact that I said that we were married, all of a sudden hands off completely. Well, ma'am, he has just as much rights to the child as you have. I couldn't file anything, I couldn't do anything. The best that they would do for me was a welfare check. We went to his house, your child is there, she's fine, we can't get her.
Gotta go to the courts.
Say it again?
Gotta go to the courts.
Exactly, and that takes time. It takes time. So in order to try to avoid that, I don't want you guys to just think, oh, Nancy said I'm a married father, I don't need to do anything to establish my rights. No, you don't, but you still need to take that extra step and get that parenting plan scheduled so that you guys don't have any disputes or disagreements down the line. Let's see. So if you're a father who was never married to the mother of the children, then the route to getting your paternity established is a bit more tedious. You'll have to go to the court, file a petition, asking them to establish your paternity over your child. Then when you serve the mother with a copy of that, if she lives in Arizona, she'll have 20 days to file an official response with the court. If she lives outside of Arizona, California, Vegas, Florida, wherever, she has 30 days to respond. Now, in that response, she's going to state whether she admits or denies that you are the biological father of that child. Once the court receives her response, they're going to schedule a hearing. It's called a resolution management conference. If mother admitted that you're the father in the response, then all they do is they swear you both in and they have you state on the record that you agree that this is your child. Once that's done, the court issues a written order giving you father's rights, and it's as simple as that. Now, if mother's difficult and she says that that's not your child, now when you go to that hearing, the judge is going to order you to undergo a paternity test. And once the results of the paternity test come back showing that you are the father, then the court will do the same thing and give you a written order giving you your father's rights. So, it's going to happen either way. It's just a matter of the route that you have to take to do it. That before you get that written order, kind of tapping on what you were saying, the court looks at it as mama's baby, daddy's maybe. Okay? So any time that you're getting from the mother as far as parenting time, visitation, she's not obligated to do that. That's her, out of the goodness of her heart, giving you parenting time for a child that has not been declared yours. You have to go to the court and have that child declared yours to have that recourse. Because, yeah, it's all fine and dandy if you guys are getting along, but as soon as she's mad, now she don't want you to see the child. And there's nothing you can do about it. And the court will back her because they have no proof that you are the father. You have to go and get that stipulation, or you have to do the paternity test. And then they open up the door for you to have equal rights.
So is that different in a married situation?
Yes.
Okay.
The married situation, you don't have to jump through those hoops. They already know who the dad is because you guys are married.
Okay.
Yeah. But if the court doesn't know, this could be anybody's child. Just because you're standing up, there could be 3 men standing up and say, I'm the pappy. Right? So how does the court determine that? They're not just going to give everybody rights. You got to go and have the mother say, no, he is the father, or the paternity test that says he is the father. So the next question is, when do I need to establish my rights as a father? So technically you can file petition even before a baby is born. Do I recommend it? No. And why? Because a paternity test hasn't been done yet. Just as I tell fathers who have a child on the way, do not sign the birth certificate until you are 125% sure that that child is yours. Although the birth certificate is not enough to get you father's rights, it is an affidavit that you're agreeing to be financially responsible for this child until they turn 18. That is a contract that you are signing. So if it turns out later that that child is not your child, the court does not care. You signed saying you would take care of them.
I think I need to hear it one more time. So signing the birth certificate does not prove paternity. It does not establish paternity, but it does establish paternal financial responsibility.
Yes.
Okay.
Yes. 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 Any man willing to step up and pay for the child, they're going to jump on that right away. You know, make you jump through hoops for everything else, but they're going to get the money, you know. So yeah, do not sign the birth certificate unless you are absolutely sure. Same thing, I think, with the petition. In the petition, you're attesting to certain things as well. So let it be found out that that's not your child. You've already agreed to certain things. Yes.
Again, I might be off here, but like that sounds good. But like, what woman is? Oh, I'm not going to sign birth certificate. Like that's an area of contention already. Like we're starting off there. If I say I'm not going to sign birth certificate.
Normally, I'm thinking about issues where you guys are already at odds, and you guys know you're not going to be together. She might have slept with your cousin and your best friend, and you don't know the baby's yours. And look, woman, I want a paternity test. Yeah.
How would you phrase it if things are like peaceful, but we don't know what the future holds?
Yeah, I would just I would go to a consultation, talk to an attorney. The consultations are usually only about $99, and then use that. Say, hey, I spoke with an attorney. They're saying these are, so don't put it on you. Don't even have to put it on you. I spoke to an attorney. They're saying these are what my rights are. This is what we should do. What do you think about it? Then you get her position. Then you know what you got to do. Do you got to go the hard route? You got to go the easy route.
Okay.
Mm-hmm.
She was like Erica Mina in that video.
Yeah.
What do you do if she refuses to have a test?
No, she can't. That would be a court order. So like I said, you'd file the petition, she'd do her response, the court schedules that hearing. At that hearing, you'll tell the judge she's not getting the paternity test. He will order her. If she violates that court order, there can be sanctions, there can be criminal charges, there can be fines.
So you got to serve her.
Yes, you do have to serve her. Yes. So yeah, establishing paternity prior to the birth of the child, I don't necessarily think that's a good idea. I think the best way to go is if you and the mother, like I said, are already having conflict before the child arrives, wait for the child to be born, undergo that paternity test, and then go down and file your petition with the court.
You don't even have to notify her to have a paternity test done.
Well, if she's refusing, like he said, then you'd have to get the court order to force her to do that.
Right, but if she's not aware that I'm...
Oh, you mean if you have the child? Yeah, you can go swap. Yes,
Yeah.
yes, that's absolutely fine.
Question too, Nancy. Though. So say,
We don't even got to talk about this.
so say like
I already did it.
dad and mom, she's still pregnant or whatever. They're kind of at odds.
Mm-hmm.
And I've heard cases where actually an old employee of mine, his ex took off to another state while pregnant.
Mm-hmm.
Would filing a petition to establish paternity
Mm-hmm.
while pregnant kind of stop that, or have her to come back, or
Yeah.
would she still be able to leave and go to just say like Nevada and have the baby in Nevada?
Yes, she would be able to leave, but once you file the petition and bring it to the court's attention, they will order her to return with the child.
I mean, even if she hasn't had the child yet?
Yeah,
Okay.
well, I mean, they'll tell her to come back because it's not about what she does. If she wants to move, the court doesn't care. But she needs to have that child back on the designated day at the designated time that you have your parenting time. They can do whatever they want. They just better not interfere with your parenting schedule.
Okay.
Yeah,
Well,
so.
I mean, though, but like even before she has the child.
Yeah,
though,
yeah.
Like, so, because I know sometimes they'll leave to establish that state as the
Home state.
The home state.
Yes,
yeah. So
yes.
would filing prevent that from having the other state? be the
Yes,
state?
yes. Once somebody moves, there's 6 months before the new state becomes the home state of the child. Once the new state becomes the home state, they get jurisdiction. So let's say mom moved to Las Vegas and you're in Arizona, you better file right then and there, because if you don't and she's over there for more than 6 months in Las Vegas, now you have to go and file in Las Vegas. You're going to have to do your parenting time in Las Vegas. You're going to have to do your child support. Everything is going to be through Las Vegas. So you want to catch that. Yeah, it's 6 months.
So this is a question about my personal situation, but it's really quick. So what happens in the case where, like, my ex-wife took my son to Atlanta? We have established our case here.
Mm-hmm.
Parenting was all done in Arizona. She took him to Atlanta, and all I was doing was paying the court.
Yeah.
For a private investigator or somebody to serve her, to file all kind of paperwork, and the court basically just said, like, there's nothing we can do.
Yeah.
So I gave him that money for no reason, essentially. And now he's been in Atlanta for 2 years. So if I want to go back and fight, I have to go to Atlanta and
Yeah.
go to Atlanta now?
Yeah, no, because you already have something established. This is for new cases.
Oh.
So because your case is already in Arizona, Arizona will retain jurisdiction. But with that situation, that would have been a situation to where you could have filed for kidnapping, custodial interference, and taken all of that evidence to the judge. And hopefully with that, he would have forced her to comply with the court orders.
Yeah, I mean, yeah, but the other side of that is, at the end of the day, that's still my son's mother, and I'm not trying to have her.
Trying to fight her.
We
And-
don't fight the fight the same way.
Yeah, and sometimes it's hard because while they're out there, the child is starting a new school, new teacher, new friends. Now,
Male influence.
yes, and now the court's struggling. Do I uproot this child from their new home that they've gotten accustomed to for father to have his parenting times? So there is a lot of factors, unfortunately, that go into it. But at the end of the day, the court is only going to care about what's in the best interest of the child. They're not going to care about mom. They're not going to care about dad. You guys are grown adults. You can pout it out in the corner. But the kid is the one that they're going to make sure is less affected by everything else that's going on around them. Yes. So I just have to say it for you guys. And then as far as after the birth of the child, you can file anytime prior to the child turning 18, obviously. And to do that, all you would need to do is go to this website, which will pull up all the family court forms for the Maricopa Superior Court. When you go to that website, you'll see a screen that looks like this. You're going to want to click on Start a New Case. From there, you're going to see a list like this. And then you're going to want to click on Establish Paternity, Legal Decision Making, Parenting Time, and Child Support.
That's for Arizona?
This is just for Arizona.
What's the difference between that and the top one, divorce with minor children?
Because this is for non-married people.
Oh, okay.
Yeah. So married without kids, non-married, and then I saw this one yesterday. I was like, ooh, juicy. Voluntary paternity when mother is married but not to the biological father. And this is why I love family law. This is why I could do it all day, every day. Yes. So I wanted to touch on something because you had brought it up, Mr. Swan, when you were talking about the father that had gone down to the meeting to speak on the father's rights. You said he didn't present well, and they ended up having to cut him off, right? I see that a lot with the petitions that you guys are filing. You guys attaching pages, 3, 4, 5 pages. No, it's not helping. It's not helping. With your petition, you want to stick to the detailed facts. You want to be clear and concise as possible. They taught me this even going through law school. The judges don't want to read all that. Their attention span is very short. So I even go through, and I'll highlight certain words. Emotional abuse, highlighted. Parental alienation, because their eyes are going to go to that. If they daze on the rest of it, at least you've pointed out the big things. But you don't want to go too long into depth. You want to, your petition, it's not evidence anyway. None of the court filings are evidence. The court cannot see any of your exhibits that you've attached until the trial anyway. They can't give it any weight. So you attaching all these exhibits and these multiple pages, it's not helping you. You sound like you're venting to the judge, which is not the time or the place to do that. So with that said, you're going to want to just put enough in the petition to get you through the door. That's it.
One more question.
Mm-hmm.
When it comes to like stepchildren, are you kind of just like at the mercy of the mother at that point?
Yeah.
Okay.
Yeah. Yep.
That's the hard part too.
Adopted children are different.
I love you more.
Yeah.
That's what it is.
Yep. They're not even included. It's a mess. Okay, so once you click on that link, you'll see a page like this. It will give you all 4 steps of the process, starting with the introduction and service. You'll click on that link and it'll give you a packet of everything that you need to fill out with instructions on how to fill it out.
May I add something?
Uh-huh.
I don't know if you guys have your cases here in Arizona already established or whatever. If your petitions and stuff are already filed, go in and sign up for the ECR, electronic courts record. So you can find a lot of these documents as well. You can see like if your ex has filed any paperwork to kind of surprise you. I check mine at least twice a month. You know, I do. It's just that's how volatile my situation is. But I also read over my petition probably once or twice a month as well, especially when the holidays. But go on the ECR online. You can set your account up, and your whole entire case file will be there, so you can see if anything has been filed against you or whatever. So.
Yeah, definitely a great resource. And that's something that just Maricopa, maybe Pinal offers, because Pima, they don't offer it. So take advantage of it because it is a great resource. Okay, so now that I've told you how to establish your rights, you're like, okay, I've done that. What does that get me? That gets you parenting time, legal decision making, and child support if applicable. Now, what is parenting time consist of? That consists of your regular parenting schedule, your holiday schedule, your vacations. It also gets down to the nitty-gritty of where exchanges are going to occur, whether the parents are allowed to take the children out of the state, out of the country, transportation, if the kid gets sick on a school day, who's going to be taking them to the doctor. I write my parenting plans to try to think of anything that would come up in the future, any disputes. I want to nip it in the bud. When you have a dispute with your significant other, you should be able to look at your petition and say, your parenting plan and say, how should this be handled? So when you get that parenting time, it goes over everything, not just your specific schedule. Now, your parenting rights, they are protected by the 14th Amendment. Specifically, the 14th Amendment of the Constitution says that each person has the right to raise their child as they see fit. Okay? Also, if you want to go down a little further to just Arizona State, there is Arizona State Statute 25403, which states that the court has a duty to adapt a parenting plan that maximizes both parents' respective parenting time. So what does that mean? That means that the Superior Court here in Arizona cannot take away your equal parenting time from your child without reasons warranting them to do so. There's 3 reasons that they can take away your constitutional right, your Arizona state right to your child, and that is abuse, neglect, or endangerment. That's exactly why as soon as you file something or you show any interest in getting your child, they run straight down there and they're filing order of protection for DV because they know that's the only way that they're going to get more time. Yes. Yes, and the courts are picking up on them now, though. You know, they're kicking them out a lot more, so I am glad to see that. So the court default is always going to be equal parenting time to each parent. What does that look like as far as a parenting schedule? Now, there is week on, week off. Pretty self-explanatory, each parent get a week. There's the 5-2-2-5. One parent gets every Monday, Tuesday, no matter what. Other parent gets every Wednesday, Thursday, no matter what, and then they switch weekends. And then there's also the long distance parenting plan where one parent will have them throughout the school year. The other parent will get like weekends, school breaks, summer break, holidays, all of that. So it just depends on what works for you guys. But there are other things that the court takes into consideration when ordering parenting time outside of just the abuse, neglect, or endangerment. Those are the 3 big things. But now we have to think about the smaller things that may take into consideration, like age or, certain circumstances. Let's say you're trying to get parenting time for an infant, a newborn. Okay, obviously they need to be with the mother a little bit more if they're breastfeeding, if they're having difficulties waking up at night, things like that. So the court will take those into consideration. Let's say on the other side, you're parenting a 16-year-old. He's got college, he's got work, he's got a girlfriend. He doesn't really want to come and exercise parenting time with you too much. Most of his friends are at mom's, he's got a life going on. the judge will take his wishes into consideration. So those are little situations that the court may take away from your 50-50, but it's not going to be to a large amount. It's just going to be for what's best for the child at that particular time in their life. Yes.
But hasn't the courts kind of gotten away from the tender year doctrine, the tender years doctrine a little bit more now?
They have a lot. They used to believe that a child should not be ripped from the bosom of the mother. That was the language that they used. But now they only take into consideration like breastfeeding and things like that. Now, if the mother comes and the child's 3 or 4 and she's like, oh, you can't have my child, I'm still breastfeeding, the court will say, no, you need to figure it out. He needs to get the child. So they don't let it exceed because of what you just said. They're moving away from that. But if there's certain circumstances that the child has, they will take that into consideration, but they will try to get you back to your equal parenting time as fast as possible.
So you mentioned those 3 parenting times. Is that set by the court, or can it be modified based off of the parents' needs?
So anything can be agreed upon by the parents. You guys can go and agree on any schedule, anything you want. It's only when you guys don't agree that the court has to intervene and set those schedules. And those 3 that I just listed are the top ones recommended by the court. They have like a specialist come in and break down, you know, kids from this age do better at this schedule, kids from this age do better at this schedule, and then they'll listen to you, hear your work schedule, you know what I mean, things like that, and they'll pick one that they believe works. Now, once you get that order, if you and mother say, oh no, that's definitely not what we want, we both agree that's the judge got it completely wrong, that's not what we want, then you guys can work together and deviate from that accordingly. But if you ever do not agree, then it goes back to whatever the court said it was. Because one thing I really need to stress for you guys is that although these are the rights that you get as a father, they are not connected to each other in any given way. So somebody who does not pay child support doesn't get their parenting time taken. Someone who's not exercising their parenting time doesn't get their legal decision making taken. You know, if they're, I don't know, if they're not cooperating with parenting time, these 3 things are, you need to think of them as completely separate from each other. When you go to court, you need to argue why you should get a certain parenting time. Then you need to argue why you should get a certain legal decision making. Then you need to argue why you should get a certain child support. You cannot combine them. And that's what I see a lot of people do. They say, oh, well, mother's not cooperating with me. She's demeaning me in front of the child, calling me names, not respecting me. I want her parenting time taken. Those things that he just listed are things that would go under legal decision making, not parenting time. Because why? She has a constitutional right to her kids if there's no abuse, neglect, or endangerment. Is her not cooperating with you putting your child in any type of abuse or neglect or endangerment? No. So the court will let her keep her parenting time, but they'll say that she's not mature or responsible enough to have joint legal decision-making authority. So I know people come to me and they get frustrated because they're like, she's doing this, she's doing that. I'm like, okay, but you can't take her parenting time for that, but you can get this. So just know what you're arguing and why, and keep it focused. I hope that helps and didn't confuse anybody more. But there's certain things, and we could talk about it more, that you have to argue in order to be successful in each one of these areas. They can overlap, but they don't really blend together. Specifically with legal decision making, there's 3 levels of legal decision making authority. Do you guys know what I mean when I'm talking about legal decision making authority? Okay, so this is who is going to be the parent who's going to decide what school your child goes to, decide what doctor they attend, what church, what religion they're with. That is the person who has legal decision-making authority. Now there's 3 levels to legal decision-making authority. There's sole, there's joint, and there's joint with final say. Just like with the parenting time where the default is equal, the default with the court for legal decision-making is joint, 50-50. That means you both have to come together, you both have to talk about it and agree, or else nothing can move forward. Nobody can make any changes. So if your child is in elementary, getting ready to go to middle school, you and mother need to talk about what school the child is going to be attending. If you have joint, you both have to agree on that new school or nothing can be done. I kind of don't like joint because it leads to, you can see how that would lead to conflict. If you both don't agree, now what? We got to go in front of the judge every single time. So then they give joint with final say, which says that both parties still need to come together, still need to talk about it, but if there's any disagreement, then one person has the tiebreaker. I like that one a little bit more because
typically decide who gets the final say?
Because of the things that you argued to get legal decision making. So off the bat, you're going to get joint. You're going to have to deal with that. But the court gives you a year as like a trial period to see what's working, what's not working. Within that year, you're going to document every time that you reached out to her regarding doctor's appointments and she didn't answer. Every time you called her on the phone trying to speak with your child and she refused to let you talk to them. Every time you tried to do custody exchanges and she's getting out the car telling you you ain't shit, you a deadbeat, and you got the recordings, you're going to get all that and you're going to get joint with final say now.
I feel like in my case, we had joint legal decision making with her having final. I got it to where we both have joint, to where neither one of us have final, but she's still been continuing to do some of the stuff like up my daughter's medicine, and now I'm going to be going for final say.
Yep.
You know? So I've just been kind of, and that's kind of like where I've been, instead of just, I've been wanting to just grab everything instead of just kind of inching my way. You know what I mean? So again, that's why I was saying when I introduced, I was like, hey, I just been wanting to, and that's what a lot of us dads do. We want to just go for too much at one time instead of just
Compound interest.
Exactly. Yep. And then splitting that interest into different banks. These are the different banks. Making sure you know that the pennies go in this bank, the nickels go in this bank, the quarter goes in that one. You have to keep it separate because then it just sounds like bleh. That's how your guys' petitions are coming out. Bleh. We don't even know what you guys want at the end of the day. So yeah. The same statute that applies to the court giving you equal time to the children also applies to legal decision making. Specifically, it states that if there is a presumption of substantial domestic violence in a relationship, the court cannot award joint legal decision making. They presume that it is contrary to the best interests of the child. Now let's break that down for a little bit because that's a lot of information. So in a domestic violence situation, there's normally somebody there that has more control, right? Somebody is the manipulator, somebody's the gaslighter, somebody's the person taking control. What would happen if you gave those people joint legal decision making? Now one person is going to feel intimidated, right? One person is going to feel bullied, you know? So in situations where that has been proven to be the case, the court will not order joint legal decision making. It's either going to be sole to somebody or final. Sole is the highest. So sole is usually preserved for extreme cases. Let's say your baby's mother is a drug addict. She's not going to get any legal decision-making authority. You know, let's say that, you know, she has severe mental health issues. She's not going to get legal decision-making authority. So sole is for those instances where there is abuse, neglect, or endangerment. The court's going to take everything. But outside of that, they're going to try very hard to stick around the joint decision-making area. Going back to the domestic violence, though, that's again why they go down there and they get those orders of protection, because they're probably being advised that with that order of protection, there's no way as a father you could get sole or final say. Okay, what if I've already established my rights and now I'm just looking for a modification? The three things that I want you to know with looking for a modification is that you're starting from a baseline. So this means you've already gone to the court, you've already established your rights, you already have a parenting schedule in place, but it's not working for whatever reason. Maybe mother moved and now you guys can't exchange regularly. Maybe something's going on and the child is telling you, I don't want to be there anymore. Dad, can I come live with you? Whatever it is, you would need to file a petition to modify. With the petition to modify, you are starting at the baseline of what your last order was. So everything that you argue from that point on would have to be new. You cannot go back and re-argue anything from before that court order. If your child had a medical condition prior to that court order, you can't come in and act like that's something new. The judge isn't going to want to hear it. If you're saying, oh, well, back in 2021, mom did this and mom did that, court doesn't want to hear it. This is the new baseline. That order that you got, whatever date it was issued, that's where you need to start from. Does that make sense?
Yeah, it makes sense. It's just, I don't know how any of that works when like the child is out of state. It's like the process. How does the process work? Like they don't enforce anything. They don't make her come back for court dates or anything of that nature.
Are they making her do virtual? Is that why?
They couldn't serve her. They got to the point, so, like, she never got the paperwork. So,
okay.
Like, it just stopped. Just give money to the court, and then they're just like, well, hey.
Yeah. That kick starts everything. The service kick starts the whole process.
Take the child, and don't have an address and things of that nature, it's SOL.
Have you done the skip trace with the process
I
server?
don't know what that is. I've hired a private investigator to get like the information and whatnot for where she stayed and all that.
Do you have any contact information for her that has worked for you in the past, like an email address, maybe
I have
even
all the
Facebook
information.
Messenger?
I'm just speaking
Oh.
on the situation in general. Like
Okay.
I talk to my son regularly now, but you know, it took a while for it to get to that point. So
Yeah.
we're gonna come across dads in that situation. Like,
Yep.
what do they do in that?
Yeah. So I have a case right now where father's in California, mother and the child are in Arizona, and we got custody parenting time awarded equal. And as soon as the court ordered that, mother refused to exchange the child. She's not allowing us to serve her. She's not not responding to emails, anything like that. We filed a motion for alternative service, and the judge allowed us to text her the paperwork. Isn't that awesome? Yes, I was allowed. That's happened twice now. I was able to text her the paperwork. Yes.
I was thinking like virtual, somebody could do it virtually or something like that, but texting.
Yep. I was. Yep.
How do you verify how do they verify that she received it? Like,
Because that's the phone number she provided to the court. So if she comes on and says, "Oh, that's not my phone number, ma'am, that's the one you provided first and foremost, and then you had an obligation to update it. And if you didn't do that, that's on you." We're not.
So there's a penalty for that, for not updating your information with the court?
The penalty is that you were technically served and you apparently didn't know nothing about it.
So
That's
if
your
she did change her
responsibility.
number,
Uh-huh.
if she didn't notify the court, she's still
Yeah.
on the hook.
Yeah. So, yep, because they just asked that you send it to the last known.
Yeah.
So, but you have to ask for permission to do it that way. You have to file the motion for alternative service. You can't just do that and say, "Oh, you're served." No, it's a process. Yeah, it's always a process.
I know it's on us, but like I would like to assume that it's in a perfect world. Like, why nobody at the court just says, "Hey, by the way, if this is what you're trying to do here."
Yeah.
It's like,
I wish they would, but I guess it's a liability too. It's money and a liability. If they tell you something wrong, they're on the hook. So, and a lot of the court staff, they're not licensed attorneys or anything like that. Burden of proof. So just like I said that you guys have a constitutional right and an Arizona state statute protects your guys' right to equal parenting time, the same thing for mom. So if you're going to court to try to modify your parenting time, it's on you to meet those elements to show abuse, neglect, or endangerment. It's not enough to say, she's emotionally abusive. You need to have an expert to sit there and say she's emotionally abusive. You can't say my children are being negatively affected by mother's actions if you don't have counseling records to show the child is being negatively. You can't just throw things out there. You have to have the evidence to support whatever you're saying. So for parenting time, if you are trying to dispute trying to prove abuse, neglect, or endangerment, that's going to be DCS records. That's going to be police reports, hospital records, counseling records, school records. Things like that are going to help you get your parenting time established. Legal decision making is going to be text messages of her berating you, belittling you, emails where you're reaching out saying, "Can I talk to my kid? Can I talk to my kid?" And she's saying no or ignoring you. Those are going to be the character witnesses. Things like that are going to go more so to the legal decision making. And then child support is a horse of a different color. I think I accidentally skipped it on there. But child support, it is what it is. The court uses an Arizona child support calculator, and it literally just punches in the figures, and whatever it says the person is going to be awarded is what the person is going to be awarded. The only things you can argue in there is your income, what you're paying for child care, the medical and dental expenses, and then any extraordinary expenses, like if your child has autism or speech therapy and you have to pay for those things, you'll get credit for that. So the way, I think I was talking about it earlier, the way the court looks at it, it takes both of your guys' income. Because if you guys were still together, that would be going collectively to the child. They take an amount that out of both of your incomes, what they think per month you would spend on the child. Whoever's making more, they'll be responsible for more. Whoever's making less will be responsible for less. Now, the person who's paying health insurance, they'll subtract it from what they owe on their side. The person who's paying childcare, they'll subtract it from what they owe on their side. At the end, the amount that's left over is what they would order for child support, because that's the money that your child would be getting if you guys were in the home together. So, I mean, it could go, if you're, one of the big factors that they look into is also the parenting time. If you're exercising parenting time, your amount's gonna be a lot less. It could be even that the mother has to pay you. But if you're not exercising that parenting time, let's say you're getting only every other weekend, then that's when your costs are gonna go up.
I thought that wasn't connected though, all three.
They're not connected in the argument that you have to get to establish it, but every time parenting time is addressed with the court, it will modify the child support because it is a factor that is used in the calculations. Mm-hmm.
Got a question on that. So I'm in the process of refiling my paperwork. Right now, I'm the only one that's working, and she's in school right now. She graduates in like 2 months, and hopefully she'll get a job. If I put it like, if I establish, because I've been paying child support since we separated. Now, if she gets a job, and let's say that my case gets finalized, and parenting plan shows that she doesn't have a job, how does that work now that she has a job?
The court doesn't care. Unless she has some kind of disability or something that's preventing her from working, they're going to assume that every adult is able-bodied and able to work. So they are going to attribute at least minimum wage. So she would be attributed, for the purposes of calculating child support, at least, I think it's $14.35 right now. So at least that you'll get. And then when she gets a job, then you can modify it even further and your child support will come down even more.
And you can modify it at any time?
So for modifications to parenting time and legal decision making, it has to be a year after the order, or if an emergency arises. If you find out that the boyfriend is beating your child when he's at mom's house, obviously the court is going to step in right then and there. If there's not an emergency though, then you have 1 year since the last court order before you can file for a modification. With child support, it's different. There has to just be an increase of at least, an increase or a decrease of at least 15%. Which if she goes from 0 to having a job, that's an increase of 15%, so you can file.
And if she doesn't report that?
I mean, when you file your petition, you have to go through discovery and disclosure. The court's going to require her, based on Rule 49 of the Arizona Rules of Family Law Procedure, to give you bank statements, paycheck stubs, tax return, W-2. She has to give you all of that, so you're going to have that information to be able to put into the child support calculator and get that ordered. Yeah, there's not, I mean, the number's what it is. She can't get in there and say, you know, Your Honor, I don't think I should have to pay child support. You do. If the calculator, there's no wiggle room, is what I'm saying. The numbers don't lie. Okay, so this one is a big one. Is what I'm arguing legal or emotional? Because like I said, both of you guys have that constitutional right. The court is not going to sit up there and micromanage what each parent does with their child. I hear arguments like, well, he's not even watching my child. Every time, you know, I give him my child, he drops him off with the babysitter. The court does not care. That's his parenting time to do what he wants to do with his child, how he wants to do it. Okay? So that's an emotional argument. If you go to court up in arms, spending all your, and this is the thing, people go to court over things that are not legal issues, and then they wonder why they've spent all this money and nothing has happened. Because what you're arguing, there's no legal recourse for. Let's say the child has autism. This is a big one that I have right now. And the mom's arguing, well, dad doesn't have any sensory, you know, equipment at the house. He's not, you know, doing this or doing that appropriately. And I'm the better parent. I've gone through the educational training. I know what's best for the child. That's an emotional argument. The judge is not going to tell that father what he needs to purchase at his home unless there's a doctor's note that says your child needs this equipment and he's not complying with that, then there's nothing that the court is going to do for that. A big one that I get again is mother's new boyfriend. My child is in a risk of its safety because mom's new boyfriend has a criminal history. He has a violent criminal history. He did 10 years. He was in and out of jail. He's got drug charges, weapons, all that. Court don't care.
So basically what I hear you saying is that if it's not on paper, it never happens.
What I'm trying to say is if your child is not being abused, neglect, or endangered, the court doesn't care that the mother's dating this man that's a horrible person. They don't care until it affects your child.
I would say I had my ex. My ex was dating a guy. He called me on just some regular random crazy stuff. Ended up doing a background check on him. He had three open felony warrants from New Mexico. One was for false imprisonment, child endangerment, and battery. And I filed it, and they didn't do anything. So I'm like, you mean to tell me I have to wait till my daughter gets hurt? Which is...
And that's the crappy part, is the court is reactive. They're not proactive. You can't go to the court and say, I think this is going to happen to my child. No, you have to say, Your Honor, this is what happened. And that's hard. That is hard. Because until then, when it happens, then you can get the DCS reports. Then you can get the police report. The court's not going to listen to just your allegations without that evidence. And how do you get that evidence? Something has to have happened.
Does it depend on the charge? Like if the ex-boyfriend, what if the ex-boyfriend had like child molestation?
Registered sex offender is the only one. Registered sex offender. That's the only one that the court will step in and get your child away from that person.
And that's typically their order as well. When it says
That goes for everybody. They don't play about that one. You don't have to ask for that. That's in there. Another one is mom has DUI. Mom just got arrested for DUI. This is what I need you guys to understand, is that there's homeless women in shelters that still have custody of their kids. There's people that get out of prison, felonies, that still get out and get parenting time with their kids. Okay, so the fact that mother has DUI does not override her constitutional right to have her kids. So I just need you guys to recognize this so you don't go wasting your time trying to argue these things in court to no avail. Mother lost her job. She's on food stamps. I need to take my kid. My kid is better with me because mom's not working. Like I said, homeless women have their kids. Mother was diagnosed with suicidal ideations. This is a big one because you would think, right, that the court wants to protect the child from whatever mental health condition might be spiraling out of control in mother's house. But what I've noticed is that the courts do not want to, as long as they're getting treatment, they're going to still get their parenting time. Because the court does not want to penalize somebody for getting treatment. Now because they think if they go get treatment, it's documented and those records are going to be used against them to take their kids. You think people are going to go get treatment? They're not. The court doesn't want that. So things like mental health is not going to come into play. So I just wanted you guys to be aware of that. This is a huge one. I don't need to establish my rights. Me and the mom get along great and we have our own agreement. I hear this all the time. But then I hear that you got a girlfriend and now she don't want you nowhere near the kids. Or she got a boyfriend and the boyfriend don't want you coming around the house to get the kids. Okay.
Both of those happen at the same time.
Yeah.
They both.
Yes. So even if you guys are great, I think that is actually the best time to go down there to the court and get that custody agreement, giving you your equal parenting time while you guys are on good terms. That is the best time. And if you guys decide to deviate and come to your own agreements thereafter, you know, the court order says we're supposed to exchange every Wednesday, but I'm doing something Wednesday. Can we get Thursday? Can we work out Friday? That's fine. You guys can do whatever you want. The court is not going to penalize you at all. But if you guys are not in agreement, then you have that court order to protect you. She can't just say, oh, I'm not giving you your kids anymore without recourse, without consequences. So everybody that I talk to, if you do not have a custody order, you need to get one ASAP because you never know when things are going to change. And it's best to get it now. Same thing I say with prenups. Get it while you guys are on the good note because the divorce is uglier. So get the prenup. So it's a similar concept. And then if you guys have any problems while going through your documents, doing your modifications, establishing your paternity, and just want to know if you're doing the right paperwork, if you're going in the right directions, have specific questions on your cases, I do $99 consultations. You can reach out to my firm at regainlaw.com. If you do end up deciding to retain us, maybe your case is a little more in depth and you do need that attorney representing you, we do offer 40% off to all of the referrals from Single Fathers Network. So normally my hourly rate is $325 an hour. With that 40% off, that drops you down to $200 an hour, and you are not going to find another attorney with my level of experience for that rate. And I do that specifically to support the Single Fathers Network and what they're doing because it's a beautiful thing. Yes. Do we have any questions?
It's pretty good. Nice and thorough.
Outstanding.
If I may say, it's been a blessing meeting Nancy, just from talking with her and just some of the things that, you know, we had our first conversation that we've had, which really attracted me towards her and what she's doing with what we're doing. Just in this right here, from my previous conversations I've had with other attorneys, not once have I ever heard any of those other attorneys even mention our constitutional rights as parents. And just in passing and our multiple conversations, that's something that Nancy has really focused on as an attorney advocating for not just fathers' rights, but even rights for our children as well. You know, so I'm blessed and grateful to have her on board and helping out Single Fathers Network so we can pass this on to you guys. So.